Going forward with Alex's motion for a new trial, we have a bunch of new documents filed between January the 3rd and January the 4th. We're going to break those down today with a few news updates, but what I really want to stress is how this witch hunt directed at Becky Hill and the thirst for blood has actually been helpful for the defense, and that's why I've stepped as far away from it as I possibly can. It extended a bit towards Justice Toal as well, but in the thirst for scandal and a villain to attack, the undertow against Alex has weakened. Has this kind of trial by media on other characters in this saga actually helped defense to build a case for Alex Murdaugh to the point that it could lead to a not guilty verdict in the future? Sadly, I feel it's possibly headed in that direction if it doesn't stop soon. Let's get started. This is Legal Updates with Cassidy. Is the witch hunt against side characters actually helping Alex Murdaugh? Welcome. To start with, we have the order assigning Justice Toal to the case that was actually filed on December 18th. And I want to start by stressing again that as soon as she was announced, people immediately began attacking her and attempting to discredit her as this great friend of Dick Harpootlian's. I'm holding back on any judgment because the same justice who appointed her also appointed Judge Newman to the case back when it first started. I don't think there was any kind of conspiracy to make this case easy for Alex then, obviously, nor do I think there is now. South Carolina has faced a lot of criticism over this case, and with the whole world now watching, the last thing they want is to appear to still be taking part in the corrupt system that was exposed to exist in many parts of the Low Country. As of now, Justice Toal has been appointed to serve the limited purpose of presiding over this motion for a new trial and all that includes. I did a short video introducing her, and she did a lot as a woman in the predominantly man's world of law in South Carolina, all while being a wife and a mother. I hate to see her attacked simply for being chosen to take on this ugly case. There may be some legitimate claims against her that may be produced in time, but for now, I'm willing to give the benefit of the doubt before straight up assuming that she's here to help Dick. In fact, I found this post made by Creighton Waters himself back before this decision for her to oversee the case was even made. This is from November the 4th. Creighton writes, with Justice Jean Toal at Judge Benjamin's investiture. She was South Carolina's Chief Justice from 2000 to 2015 and trailblazing first ever woman in that role. Meant so much to hear she was proud of me because I was so fortunate to learn in oral argument before her court. If I could do the work and prep to survive aggressive questioning from Chief Justice Toal, I could hang anywhere. An amazing person, lawyer, and jurist. So she openly expressed pride in Creighton's work. He mentioned that he learned oral arguments in her court. He called her an amazing person, lawyer, and jurist. So again, I want to stress, this was well before she was chosen to oversee the Murdaugh case. So these are his real feelings about her, and hers about him. It gives me hope, and I hope it does for you too. Next, we see the reason this document was refiled here. There's a new order for all filings in this case going forward. And it states in part, because defendant's motion for a new trial contains allegations related to the conduct of the Colleton County Clerk of Court, I find it would be inappropriate for documents in this case to be filed in Colleton County. Therefore, it is ordered that all documents, orders, and correspondence related to the resolution of the defendant's motion for a new trial shall be filed with the Clerk of the Supreme Court of South Carolina. And then she asked the Clerk of Court of Colleton County, which we know as Becky Hill, to transmit a copy of the October 27th motion for a new trial, and then any and all subsequent filings should now be filed in the Supreme Court. Everything was filed in the Colleton County Courthouse because that's where the murder trial took place. But because the larger part of this motion for a new trial involves accusations leveled at Becky Hill, the clerk of that court, nothing will be filed there anymore. It will all instead be filed at the Supreme Court, and this document is to notice everyone involved where to file their motions and correspondence in the future. We'll skip the next one. It's an email. It's just the email sending this order forward to the clerk of court and to counsel. So moving on, we get to the first motion, which is the pre-hearing brief on behalf of defendant Alex Murdaugh. This is a pretty sizable file, so it will take up most of today's episode. It's also the most irksome of all the documents. From it, we learn that there was a telephonic status conference on December 21st, where the court requested that this brief be submitted. It gives the background of the murder trial, the indictment, the convictions, the sentencing, and the filed motion for a new trial on October 27th. The allegations of which are that Becky Hill had extensive private communications with members of the jury during trial. It also alleges that she deliberately violated Alex's constitutional right to a fair trial before an impartial jury, again stating that if it's proven, the law requires a new trial. So that will be the basis of this entire brief. Now remember, this is just a brief written by Dick Harpootlian. He states things very confidently, but these are not approved by the court. They're to be decided upon. And that's the main part of Justice Toal's job. So he speaks a lot of these things as if they're fact when they are not. Starting with part 2, the argument, he states Mr. Murdaugh does not need to show actual bias on the part of any juror to obtain a new trial. So that's his statement, and his reasoning is that if Mr. Murdaugh proves his allegation that Ms. Hill communicated with the jury about the evidence presented by the defense during his murder trial, South Carolina and federal law require that Mr. Murdaugh receive a new trial, irrespective of whether the court believes the outcome of the trial would have been the same had Ms. Hill's jury tampering not occurred. That's his interpretation. Now, I've already covered this. It was a review of the state's response to these same allegations. This statement is, in fact, not supported by established cases in the South Carolina Supreme Court, and I'll have these linked in comments. But let's turn over to the state's brief, which is Document 9, and we'll be viewing these briefs simultaneously because here is the big disagreement. Defense is saying that no matter what, if it's proven that Becky said what egg juror is claiming, Alex gets an automatic new trial, that this is the only remedy. And here we have the state saying, hey, we can't put the jurors on trial. This burden lies with defense to prove, but in this area, I have to say it's really impossible to prove it without questioning the jurors. So this particular issue has already been ruled on and an evidentiary hearing set, as we'll see. But this reasoning of a prima facie showing was also covered in the state's response podcasts, the same ones I've linked here. In those, there was a case that the state cited in their reply of a bailiff speaking with the jurors while they were deliberating. It was a statement that could have affected how the jurors decided. The Supreme Court did not agree with what Dick's saying. They resolved it with voir dire and a polling of the jury. This is going to come down to whether or not we believe egg juror and her tenant, juror number 630. As discussed in these podcasts I've linked here, we do have reason not to trust egg juror. She has lied to the court. She's the one, the only one, who made this allegation, and then her tenant, juror 630, backed her up in an affidavit. As a reminder, neither egg juror nor juror 630 participated in the interviews by SLED, so only their affidavits have been supplied to the court. It's very odd indeed that only the embittered egg juror and her subordinate, her tenant, the person who relies on her for a place to live, have made this claim. Of the rest of the jurors, those who claimed she spoke to them did not say she told them not to believe Alex. The statement was the same statement they heard Creighton say, which was watch his movements and body language. Saying watch his movements and body language could go either way. It's open to interpretation and is not telling someone what conclusion to come up with, as Dick has stated in this motion. I'm not saying that this is okay for her to have said this if she did. I'm simply stating that this is not a correct retelling, and that based on decisions made in higher courts and upheld by the South Carolina Supreme Court, a new trial is not the requirement for these statements. He reiterates the claim that a state official argued the merits of the evidence presented, using her official authority to direct the verdict. This is why we need the evidentiary hearing to finally get to the bottom of this. As much as I'm against a new trial, I admit it's more likely than not at this point, and it's a real shame. He goes on to assert his own opinion, and even stronger, when he states, even if every juror were to testify that he or she would have reached the same verdict regardless of Miss Hill's tampering, a new trial is required if it is proven that Miss Hill communicated with jurors about the merits of the evidence presented. But again, as I've already mentioned multiple times, this is not the established precedent in South Carolina cases, as has been upheld by the South Carolina Supreme Court, especially if her statements were actually in line with what the majority of jurors have stated. Unlike the state's motion that cites a similar case as they can find, with Supreme Court decisions to support them, Dick chooses to cite Nieder v. United States. This was a case involving taxes. The court allowed the exclusion of evidence deemed immaterial, and when the case was reviewed by the Supreme Court, they agreed. They upheld it. This quote he puts in here is from Justice Scalia, who is the only justice who dissented and disagreed with the decision. He made the statement, though the official decision upheld the district court's decision. So this is a statement by the losing opinion of a case, and not the decision actually upheld by the Supreme Court. For a case that couldn't be more different than Alex's case. So different, in fact, I'm not sure why it's here. It's not a similar case by any stretch of the imagination. But apparently, he liked this quote and thought he could apply it. This next case was upheld in the Oregon Supreme Court, but reversed by the U.S. Supreme Court. However, I will stress that in this case, the agent was a bailiff and not a clerk, but his statement was not similar to Becky's, if she in fact made the statement she's been accused of. This man didn't simply say watch his movements. This bailiff outright said, he is guilty. There's no question what this bailiff is saying. He also called him a wicked fellow. Not the same situation at all. Now we find one of the very cases that the state used to prove their side, and this is one that's covered in these cited podcasts. The Supreme Court upheld the decisions, so I hardly see how this helps their case, as it went against what they're trying to accomplish here. Then we see where he's going by claiming that Becky's statements go beyond the statements made in the Green case. But he says again, the state official told the jury not to believe the defendant's defense, or his testimony when he testified in his own defense. I cannot stress enough, these are unfounded accusations at this point. What he omits here is what the jurors themselves had to say, and more importantly, that Becky has not been found guilty of these accusations. This is yet to be decided by an evidentiary hearing, but for fun, let's review yet again what the jurors had to say. For those of you who haven't seen this chart before, these were questions presented to the jury, those who had part in the verdict, during an investigation by SLED into these allegations of jury tampering. In addition to this, they also had to write out their personal statements. The second column was where SLED asked each juror if they heard remarks by Becky Hill on the evidence. And we'll go down them. One of them said no, except for maybe generally pay attention. The next one said that they heard her say, "Watch Murdaugh's body language." Again, does not say, "Don't believe him," as Dick is claiming. Third one said no, other than a graphic material warning. Fourth one said no. Fifth one, no. Generally pay attention, look at body language, and be observant. Does that lead one way or another? Guilt or innocence? Or is she telling them to pay attention? Mind you, I'm not excusing her saying this because she shouldn't even have said this much. What I'm saying is this is not what Dick is claiming in this motion. Dick is saying she said, "Don't believe him." Next juror, no. The next juror declined to discuss the case or deliberations. Some of these jurors are being represented by Attorney McCullough, and we'll get to that later. Next juror, no. The next juror, 630, is the one who is a tenant of the egg juror. The egg juror is upset. I spoke about this in a previous podcast. The impropriety of an authority figure, such as a landlord, serving on a jury with their tenant. There's a bit of authority here, power here. One needs to please the other. This is inappropriate in itself. Naturally, juror 630 may feel a little uncomfortable to not support their landlord. And that's who this 630 is, who had not been interviewed at the time of this poll. Next juror, no. Generally pay attention. Heard no body language comments. This juror was also referred to in the egg juror's affidavit. This juror denies those statements. Next juror, no. Last juror, no. And in their statements, they say it was Creighton Waters in court arguments who told the jury to watch body language. Now, this is important because a lot of time has passed. This was a long, long trial. 6 weeks. A lot happened. Very emotional, very stressful, very tiring. And it was some time before this interview. Can we rely on perfect recall in a situation like this? I don't think so. Sometimes it's hard to remember exactly a conversation from the previous week, let alone letting months pass by. It wasn't one day in court, it was 6 weeks. A lot of things happened. Is it possible to confuse what came out of Creighton's mouth from what came out of Becky's mouth? Yes. Did it? I don't know. I guess at this point we can't really know that. But there's nothing on here that says that she told anyone not to believe Alex. Now, the egg juror wasn't part of this investigation where they questioned the jurors because egg juror had no role in the verdict. The egg juror was dismissed before deliberations began. Not only that, she definitively lied in multiple statements since voir dire, where she was initially selected to be a juror. Her lies, in fact, are a matter of record at this point. Her credibility is destroyed at this point, so I will not entertain her statements, especially because of the fact that the only other person supporting her statements is her own tenant, Juror 630. In summary, the jurors themselves do not state anything at all like what Dick is claiming that Becky said not to believe Alex. And this is why I say the cited cases that he mentions are not similar enough to assume that we can apply their findings in this case. And then they have the gall. I mean, this is so rich. Dick quoted from a case about taxes. He quoted a justice from the losing side. But then he proceeds to ridicule State for quoting State versus Kelly, saying that this case has nothing to do with the present motion. He says, well, in this case, a juror was accused of misconduct, not a court official. He says the trial judge determined that a mistrial was not warranted because it was not relevant to the issues in the guilt phase of the trial and because no other juror had been exposed to the contents of this pamphlet. And the Supreme Court agreed with this. This case is also one in the previous podcasts that are linked. But the relevance is that it also involved a potential risk for tampering with the verdict. Therefore, how the court deemed the correct way to handle a jury being tampered with is very relevant indeed. You're not going to find the exact case that you're trying. What you have to do is find the principle from a previous case that set precedent that could be applied to your case. So why wouldn't a case about potential jury tampering be relevant to this case about potential jury tampering. The bad news, however, is that Justice Toal dissented on the Supreme Court's decision and felt that the jury could have been tainted by the pamphlet in that case. This happened to be one of the cases that was put before the South Carolina Supreme Court during her time there. So it does raise a slight reason for concern about what her decision will be in this case. Now, I hate to keep repeating this, but again, this is the guy who cited a case about taxes in which the Supreme Court took the side against what he's trying to prove here. And yet he's once again ridiculing the state's choices of citations. Rich indeed. Anyway, he states this case says nothing about the standard for granting a new trial when a state official tampers with the jury. As I already stated, we won't find the exact case to match it, but this case involves alleged jury bias. So naturally, the remedy the court saw fit in that case is very relevant. This time, it's not the South Carolina Supreme Court, but the U.S. Supreme Court that held. This court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. And in that case, they determined that no actual bias was proven at the hearing, which could very well come out in Becky's case. Why wouldn't the remedy be the same? Now, I don't want to spend more time on all these cases because we have several other documents to get to. So we're going to move on at this point to the next point. C, the applicable standard of proof is a preponderance of the evidence. So here Dick is acknowledging that the applicable standard of proof is a preponderance of the proof, but he feels that if it can be proven that Becky engaged in surreptitious advocacy on the merits during the trial, that a new trial is required. But so far, the evidence goes nowhere near proving that she did. The next point is moot since the court has already scheduled an evidentiary hearing, so we'll skip that other than to mention that in the state's brief, they make some very important points. Not a single juror who actually deliberated on the case indicates that their deliberations or verdict was in any way affected by the improper contacts alleged. The jurors were polled individually and affirmed their verdicts on the record. Murdaugh offers with his motion an affidavit from only one juror who deliberated, Juror 630. In the affidavit, Juror 630 attributes statements to Clerk Hill which resemble arguments made by the state, but she does not claim that she was influenced by Clerk Hill, but rather merely felt pressure from other jurors, and then points out, as set forth by State v. Franklin, due process is not implicated by pressure upon one juror by other jurors. These are also important considerations. Juror 785, the so-called egg juror and landlord to Juror 630, did not participate in deliberations and was removed for her own violations of the court's instructions not to discuss the case with third parties and lack of forthcoming candor regarding those discussions. Further, when asked by Judge Newman at trial if Clerk Hill discussed anything about the case with anybody on the jury, Juror 785 replied, "Not that I'm aware of." The affidavits in the defense motion on their own do not support a new trial, and the motion should be denied on the pleadings. Lastly, none of the other jurors who deliberated who spoke to SLED after Murdaugh filed his motion indicated that their verdict was in any way based on anything but a fair consideration of the evidence. Part E, in the state's response, the state asked the court to strike some of the defense's so-called evidence, which included affidavits made by paralegal Holly Miller, statements regarding jury deliberations, and those silly Facebook post claims. This was all clearly explained in these two-sided podcasts, so I'm not going to go into the details. There is sound reason for their exclusion, especially the affidavits, and the Facebook posts cannot be traced to Becky Hill in any way. I can't imagine a court allowing either of these things. I can see the court wanting to make their own ruling on number 2, though, these statements regarding jury deliberations. And he's very bothered by these statements about Holly's affidavits. He goes on to contest it, saying that they were only evidence of what certain jurors might say in testimony. But that's not what we found with the jury statements. There are 2 yet to be heard from, but most of this is based on the egg juror. And one of the jurors that Holly wrote an affidavit for denied the allegations that are in the affidavit in their own written statement to the court. So perhaps he's so angry because he's a little embarrassed. Then, instead of addressing the validity of the Facebook post itself, which is submitted as evidence by him that Becky tampered with the jury by planting this post, he goes into a long, drawn-out monologue on the accusations against Becky. None of this is relevant to the Facebook post. None of it provides proof of his allegation that she created it. None of it. Even if she is found guilty of these things that he lists out accusing her of, it still does not give credence to this unsubstantiated claim that she created this Facebook post. There is simply not a sliver of evidence to support it, and because of that, the state requested it be struck. In the state's response, they said that the only relevance of the Facebook post was to impeach Miss Hill, and he takes that as an excuse to list all these other reasons to impeach Miss Hill. But as far as things go, this hearing doesn't have anything to do with all of these other accusations. This hearing is an evidentiary hearing simply to determine whether or not she tampered with the jury. All of the rest of this, irrelevant. Did she or did she not tamper with the jury? That's the only thing this evidentiary hearing is for. Should the other claims be investigated? Absolutely. Obviously they will be. But for the Alex Murdaugh trial, only relevant information about Becky Hill is whether or not she tampered with the jury. In the next point, they assert that they do not need a preponderance of evidence that Becky made statements to at least one deliberating juror, and they feel that it will be corroborated. He again brings up this line about the jurors not being fooled or misled that none of the other jurors so far have corroborated. In fact, they flat out said it didn't happen. So this is what needs to be sorted out in the evidentiary hearing. And he again tries to tie in these other accusations against Becky, going on more to express why he feels all this negative evidence against Becky's character should be allowed. But again I say, all of these other accusations are to be dealt with in another court, on another day. And if she is indeed guilty, punishment decided at that time. But even if she is found guilty of every single one of those accusations, it does not make her guilty of jury tampering. That, I'm afraid, will still need to be proven in the evidentiary hearing. You cannot simply say, she's a bad person, she did this and this and this and this, so she obviously tampered with the jury. It makes no sense. And looking back at the state's document, they're reminding us exactly of that. Regardless of what Becky Hill may be found guilty of otherwise, it's really just about how the jury arrived at the verdict they arrived on, and whether or not Becky was a deciding factor in it. All of the rest of this is a distraction to take the heat off of Alex and help him get a new trial. And it's sickening. Like it says, the jurors found Murdaugh guilty, affirmed that verdict when polled, and none have alleged that Clerk Hill influenced them. That is the only important piece to this hearing. All the rest of this is for another day and another court. And here is where I got the most irked. This means to sell subscriptions, obtain views, and otherwise make a name and money for yourself has led to a very dark and dangerous style of reporting. It's the rare person who is able to stay unbiased while reporting on a story, especially a story like this. Most news outlets are very strict on this policy, but once you get outside of professional news outlets like CNN and TV news channels, we get to podcasters, YouTubers, and such. People like me who love to share the details that they've discovered with audiences who are just as excited to hear about it as we are to share it. Now, I will openly admit I am very biased when it comes to the Alex Murdaugh case. I believe with every part of my being that the jury got the verdict right. It does no harm to refer to Alex as guilty, since a court of law found him guilty and he has been sentenced for his guilt. We no longer have to say allegedly when referring to him killing Maggie and Paul. It's accepted as fact once it's been decided by a jury and upheld by the court. So declaring him guilty, there's nothing wrong with it. No defamation suit can come out of it, no slander suit, unless a court overturns his conviction. News agencies the world over can call him guilty. He is considered guilty. He's had his day in court. But Becky, as of now, these are all accusations and allegations. We cannot declare her guilty. We cannot assume that every accusation made against her is true. We can't say what Dick says here, that she's impeached herself by all these accusations. Now, I'll admit, when I first heard the accusations made by Dick and Jim at that press conference, I hastily made a video about it. I went too far. I assumed the worst right off the bat. My title, look at it, "Oh Becky, what have you done?" Now, in subsequent podcasts, I pulled it way back, reminding myself that these were only accusations at this point. Now, as more information comes out, she does appear less and less innocent, but it's not up to me to decide her actual guilt. And here's why it bothers me so much that others are aggressively doing just that. These are exhibits for the defense. These are exhibits to present before the court to say, Alex deserves a new trial. We have aggressive news agencies on their witch hunts providing defense with exhibits. If a piece of my post enabled Alex to get a new murder trial, that would be it for me. I would seriously have to reconsider what I'm actually doing here. Here's the other danger. Lumping these Becky accusations so tightly interwoven with Alex's story muddies the waters for future jurors by misdirecting attention. When people are relentlessly attacking her in the same ferocious manner as a murderer, it sends a terribly wrong message that not everybody is able to separate. If Becky's evil, Alex might be innocent. This is absurd, but it's happening. You can see it on social media everywhere. In places that are supposed to be exclusively about Alex, you see more about Becky than Alex. More about Becky than Corey, one of Alex's accomplices. More about Becky than Russell Lafitte, the man who made it all possible. He gets by, hardly a story about him. If there's a story about him, hardly any views. No one's interested. But Becky Hill has already been tried and convicted and living in a sort of prison at this time. Instead of the accusations against her being their own separate story, played out when they will actually be addressed in court, they've become one and the same with Alex's murder trial. All that's before the court at this time is whether or not she tampered with the jury. The jury has made written statements to the court, and even those were very far removed from the trial by time. Now, with even more time passed, and hearing all of these accusations, how is this matter going to be fairly heard? Jurors are often sequestered in high-profile cases because of the fact that media and people talking about the cases can affect their opinions. Now, we're dealing with the fact that a fair recall of memories for these jurors has long since passed. We've now heaped days, weeks, months of accusations, muddying the recall they do have left by painting this whole new picture of Becky from the one that they had at the time they were actually jurors. How messy are their memories now because of all this? How changed could their recall have become by all of this. The way they look at Becky might be different now than the way they saw her then. And all that matters now is the way they saw her then and the recall of what she did then. Now it is so muddy by time and by the media. We're to the point where it's really not even fair. Now, I'm not defending Becky. As I mentioned, I also spoke out against her out of frustration on the day of that press conference. I'm extremely frustrated that her actions may have brought all this about. I've held my tongue since then because I'm not a judge and I'm not a jury to decide her fate. If she's found guilty, I'll report on it. But at this moment, and in view of the importance of the matters before us, I personally don't feel it's time for me to express my opinions or to try to influence anyone's ideas of her guilt. Most importantly, I'm so very sad to see the effect that attacking her has had on this case. I don't see the difference really in Becky ruining the case or efforts by overreaching media ruining the case. The case is being ruined. And it's not just by Becky at this point. In the end, anyone helping Alex literally get away with murder bears the same amount of guilt, in my opinion. Well, that's my rant for the day. And this really is the heart of the matter. Turning back to State's brief, Part 3 says, judicially conducted, limited questioning. Should the court deem an evidentiary hearing necessary, the procedure should be judicially guided and the scope of relevant evidence is limited. And this is for the juries, as it goes on to say, to minimize intrusion into the lives of those who performed such public service in this case. Let's not beat this jury to death. They did a difficult job. They did it well. They're not villains. And then it also mentions this very important case, State versus Green, that set precedent for how this additional inquiry should be conducted. The only two important questions are here. On March the 2nd, 2023, which is the day they delivered their guilty verdict. Did you answer when polled that your verdict was guilty on each of the charges? Number 2, as you were instructed to do by Judge Newman, was your verdict on March the 2nd, 2023, based solely on the testimony, evidence, law, and arguments of counsel as presented at the trial? This is all that matters. Underneath this witch hunt, underneath this public shaming, underneath the gossip mill, lies the only thing that matters. Summed up by these two questions, as carried out in State versus Green when a verdict's fairness was called into question, this is how it was handled and approved by the Supreme Court. Only these two questions matter, and that's summed up by the last statement, preserving the focus of the proceedings upon the allegation actually raised by Murdaugh's motion. I know a lot of people are hyped up about a new trial. Millions of people have joined the story after the fact and would love to see it happen again in real time. Media channels haven't had the same amount of views around a story this big for some time, and a new trial will accomplish that on an even bigger scale now that more are watching. There are a lot of reasons pushing for this new trial is a priority for so many people. But beyond all of that are these two questions that should be presented to the jury. Is a whole new trial actually warranted? Cut away the hype, and there's a very simple answer. South Carolina Law Code makes it clear that the scope of questioning jurors is very limited indeed. In the state's brief, we find Rule 606B quoted. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberation or to the effect of anything upon that or any other juror's mind or emotion as influencing the juror to assent to or dissent from the verdict or indictment, or concerning the juror's mental processes in connection therewith, except that a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. Is it not clear as day? We can see the state trying to talk sense here, trying to reel it back in knowing that Dick and Jim are going to try their best to turn this into a circus of a smear campaign. As they say, defendant wishes to make central his focus on the credibility of Clerk Hill. However, Juror 785's improper contact with third parties was the catalyst of the inquiry into the juror, and the trial judge specifically stated on the record that nothing to do with the Facebook post had anything to do with excluding the juror. Murdaugh's attempt to challenge his own valid conviction cannot be a vehicle to issue witness subpoenas to those with no testimony relevant to the underlying question of whether improper contacts occurred and whether prejudice flowed therefrom. The relevant questions are for the jurors. Egg juror had no part in the verdict. So starting with this nonsensical Facebook accusation, to which we all heard Judge Newman express had nothing to do with her removal as a juror, this cannot be a vehicle to subpoena those with no testimony relevant to the underlying question, which is the question of the verdict. The state here sees the potential for this evidentiary hearing to quickly become the Becky Hill show, when this is about the verdict of a double homicide. Let's not forget that 2 people are dead, painfully shot to death with multiple shots by the very person on this earth that should have protected them. And then the state pretty much begs the court to only allow exhibits related to what is actually at question here, to stay grounded, to stay the course, where they say potential exhibits should be limited. In Part 4, the state proposes few exhibits are relevant in any potential evidentiary hearing. The state asks the court consider as exhibits or otherwise part of the record the transcript of the trial, which in particular includes Judge Newman's repeated instructions to the jury to base their decision solely on the evidence, the in-camera hearings regarding the removal of Juror 785, which excludes the Facebook information because it's not why she was removed. Back to the document and the jury's verdict and affirmation upon polling. These jurors all say they found him guilty. Moving on to the next point. He then asked the court to allow the jurors to appear on camera with only redacted transcripts supplied to the public. I have to say I was a little irritated by this. Not for all the jurors who got drug into this by the claims that were made by the egg juror. I feel sorry for them, but a part of me feels like if you're going to make statements like the accusations that the egg juror made, come to the public court and make them like everyone else. If egg juror wants to make these claims, bring it before the court. How many rape victims, for example, have had to sit in open court and face the accused while telling the most horrific violation of their bodies? How many relatives of murder victims have had to sit in open court and testify before the murderer? The least this egg lady can do is face the court while she tells her uncorroborated story instead of hiding like a coward. Why should she be protected? But that's my irrational thought. Like I said, the rest of the jury are being drug into this because of her, so yes, they should be protected, as they're not doing this of their own accord. They did their duties, went on with their lives. They shouldn't have to sit before everyone, lose their anonymity if they chose to keep it. But naturally, it would be considered foul to single her out. So overall, if this is what it takes to protect the rest of the innocent ones, I do agree something should be done to protect them. I also agree with the next part that if Judge Newman must testify in any way, that he should be allowed to testify on camera and not in open court, if that's what he prefers. And yes, Becky should have to testify in the open. But I feel the ones making the accusations of misconduct should have to as well, just like any other witness out there has to make their accusation before the court. Next, he mentions not allowing counsel to participate in the proceedings. Specifically, they name Eric Bland. We know he's been a thorn in Dick's side since the beginning. Eric Bland represents some of the jurors, and he quotes some things that Eric said on his podcast. I think there are valid points here, since the jury is not actually on trial, but they're simply witnesses. So what role would their attorney serve here in court, actually? I agree with that. They should be simply allowed to speak for themselves, as witnesses do. Then in the conclusion, after spending a lot of time on speculative accusations against her, he finally dials it back to the one and only important thing: jury tampering. And that wraps up this document. From there, we move on to the scheduling order, and there are two things currently on the schedule. There's a status conference on January the 16th, and then the long-awaited evidentiary hearing, which is scheduled for January the 29th, and they've reserved a few days up to January 31st if needed. So those will be here before we know it. The next document is exciting. It's an order regarding media coverage, and it's going to outline the rules for the conference and the hearing. The exciting bit is it will be televised. So far, I'm liking the decisions that Justice Toal has made. She could have chosen to keep these off air. Instead, she's allowing it, but with some restrictions. For example, cell phones, computers, smartwatches, earbuds. Anything that could be used to transmit will be banned from the courtroom. And this was interesting. This wasn't the case when I attended a hearing. I was able to bring in my bag. But in this case, they will not be allowed except for the participants and court personnel. The rest of the public, including news organization representatives, will have to bring their items to the courtroom in a clear plastic bag. They're also limited for what equipment they can use. Even the representatives of news organizations, they can have handheld micro-cassette recorders. We're going back to the 90s, folks. They can use cell phones and laptops just for the purpose of taking notes. But if this equipment becomes a distraction, they could be kicked out of the courtroom. Court TV will be the only ones allowed to actually be filming. This worked out bad for the hearing that I attended because something was wrong with their sound. So every single stream that came from Court TV had bad sound. So let's hope they get that right this time. Like when I was there were other agencies that were allowed to connect to Court TV so that they could stream it. And it does give the assurance that Court TV will not claim any copyright for the use of their audio or video. As far as news agencies, the state newspaper, and perhaps others. But as of right now, it's just the state newspaper will be allowed to take still photography. And they will also make no claim of copyright in any photographs that they obtain. And this is really to limit the number of people walking around snapping pictures. When I was there, very few pictures were actually taken, and I only saw 2 guys doing it. Now, images obtained outside of the courtroom and the court proceedings will retain copyright. So reposting anything outside of the court, you could end up with a copyright infringement. And if you plan to attend, there is some reserved seating set aside for news agencies, but it's otherwise open to the public. So that was exciting news to hear. We will be able to watch this on TV. The 7th document is the copy of the request for a new trial that the court requested be refiled here. We've covered that a long time ago, so we're not going to go over that again. The 8th is an email with the scheduling order and media coverage orders that we've already discussed here. 9 is the state's brief that we covered together with the defense's brief, so that brings us up to document number 10. This is a standard motion requesting discovery and disclosure. This keeps either side from bringing up surprise evidence at a hearing or trial that the other side has not yet read or had the chance to examine or prepare to rebut. And it basically just requests that all such evidence be handed over in a complete and timely manner. So we move on to document 11, which is a proposed order for protection, and this has been submitted by the state. This order request reminds the court that there's international interest in this case. And I want to point out attention to this one paragraph that says that SLED has interviewed numerous jurors and collected video recorded statements which unavoidably reveal their identity. It is essential to the protection of these jurors that the identities remain secret and essential to the legitimacy of the judicial system of South Carolina that the rights, privileges, and common dignity of its citizen jurors be zealously protected. I think the jurors' thoughts and feelings get terribly ignored in this whole mess. Imagine how many people, some well-meaning but intrusive nonetheless, others maybe not quite well mentally. The sheer amount of people who want a piece of them must be utterly overwhelming. I can't imagine how many times people have attempted to reach out to them. Their lives have been turned upside down by this case, and now they're being drug out into the open once again, and the verdict they came up with being questioned. They've had Dick drive up on their homes, the validity and integrity of their verdict questioned. I would be offended if I sat through 6 weeks of trial, came up with my verdict, and then had others question it. 10 months later, they're being called back, and the verdict they gave with the best of their ability being questioned before the entire world. I feel bad for them. And let's remember, not everyone is looking for fame and attention. These are everyday people. Most of them have chose to keep their anonymity. And if that's been their choice, this is not some great chance to be seen, to be known. It probably feels scary. I would be scared because society as a whole is scary. This case is divisive. It's out of control, more so now than when they sat on that jury panel in the first place. They probably feel like they're being pulled in a million directions. Can we think about these people for just a moment here? Back in this document, they stress so much that this information about the jury is only to be used for this case and cannot be disclosed outside by anyone. As I said, let's remember Dick and Jim drove up to these people's houses. Several of them, when they were questioned by SLED, mentioned that they felt threatened by Dick. They actually used the word threatened. This shows you how very uneasy they all are with this and why it's so necessary to protect them. After all, it was only the egg juror who was interested in telling everyone that she served on the jury during the trial. The others kept their mouths shut. Very few went on to be interviewed on TV. This poor jury. The last document is both 12 and 13, with 13 being the email that carried the order to counsel. And this is the order, number 12, that Justice Toal ordered in response to this protection being requested. It starts off saying the court recognized that a protective order is necessary in this case. So she so orders it to protect the information provided by them to the defense. She also goes on to prohibit any staff from disclosing the information. She also orders the detailed manner in which such information is to be stored. In the footnote, she even mentions requiring special passwords for any digital evidence. She goes on to extend this order to anyone who receives it and applies it to the state as well as defense, but she doesn't require that anything filed be under seal. So, that concludes the last of our documents filed up to now. I'll definitely be on the lookout for any new ones added and will keep you updated. The big news here, just by review, is that all files will be filed with the Supreme Court instead of Colleton County Courthouse. Judge Toal has scheduled a status conference on January 16th, and an evidentiary hearing has been granted and is slated to begin on January 29th. She will allow media to attend, though all video and photography are to be conducted by Court TV and the state newspaper up to now. There may be some added for that, and they will share these without copyright. In other news, Russell Laffitte has filed yet another appeal, and we're talking about massive files on that. I will be covering that soon, as well as continuing the story of the claimants for the last of Alex's funds that I started early last month. I'm sorry I've been away for so long. My life recently has been a series of unfortunate events, it seems. But I've missed spending time with you here and reading your comments and your takes on all of these things. I promise to be back again very soon. Till then, this is Cassidy O'Connell saying stay well and stay tuned.